How's it going?
Good morning.
Hello, how you doing?
Not too bad.
Good. Hi, Jason. Hi, Aiden.
Morning.
Did you guys do anything interesting over the spring vacation?
I went to Chicago for St. Patrick's Day.
Oh, are there like drunken marches? I shouldn't say that. I'm stereotyping. The Germans in South St. Louis, where my relatives grew up, they were always afraid of the Irish in North St. Louis. My mother used to caution me when I went to school on St. Patrick's Day, be careful, those Irish are rough. So I'm afraid it was that stereotype that was playing out 50 years later in my comment. I shouldn't have started the recording already. So I entirely apologize for that stereotyping of Irish Americans. Did you have fun at the party in Chicago
That's
on
fun.
St. Patrick's Day?
Good time.
Good. What about down there? And where are you? Arizona or New Mexico?
New Mexico, Santa Fe.
Yeah. Actually, I was down in
Pretty
Arizona
good.
last week in Tucson. I was doing some babysitting of my grandkids, and boy, it was beautiful down there. It was nice to be away from the cold weather. Here, let me
I
give you
spent a
guys.
few days.
Yeah.
I spent a few days in the southern part of New Mexico. I have a pair of property down there with a trailer on it, a camper trailer. So I spent 4 or 5 days down there just to hang out and open it up for the season.
Oh, nice.
Yep.
So you just go down there. You spend most time down. When is the time you go down to your trailer in the southern part of the state? Is it summer, winter, spring, fall?
All three. I go down fairly often.
Oh, okay.
And I use a thing called Travelify. That's for campers who go out and you can get internet service because it triangulates all the towers that are around. So I can use internet there and I can do school work from my trailer and everything. So I go down, hang out, do yard clearing of the property because it's all undeveloped. So I'm clearing their property and getting things done. Septic is being installed right now, actually.
So are you going to move down there permanently, or is this just a place to get away to?
For now, it's a vacation spot, but in a couple years or so, we're looking at building a house down there, moving there.
Nice. Okay, here, let's see. Jason, let me give you credit too. Did either of you guys do the extra credit essays? I haven't gone back to grade those yet.
I did not.
I didn't do extra credit, but I did do, of course, the regular essays, although they were different than what you had put out before. So I had already answered what was kind of there. So, so I was like, well, it took me some time. So I was like, I don't think I have a lot more time to do much more of this. I put in what I had, but
So you saw two versions of the essays?
mhm.
Where? One on the test and one where? In the like the
In the email when you have, or what we were talking about at some point, you had a description of this was going to be the first essay. Here's the second one. Here's
uh-huh.
your extra credit, and then you had a little bit different on a test. They were slightly different, the essay questions. So they had some differences to them. I didn't quite.
Well, I'm sorry for that. I have
That's all
changed them
right.
around from time to time. And uh
Yeah.
hi Jenny, let me give you a
Good morning. I found you. I must have been on a different Zoom link.
I wonder what Zoom link you were on.
I don't know. They were from your emails, and then I emailed you too. I was like, I thought classes were resuming. I was like, I must have the wrong Zoom link. So I found you.
I wonder, so you were where you didn't find me was on a link I had sent at some point?
Yes.
Well, you know what? I better real quick send this. I mean, this is the link I think I have used for the classes every time. I can't think, but we might have had a different link. I might have sent out, I did send out a different link. You remember when I had that in-person class?
Yes, and that's what I was on, and I was like, I have to have the wrong link or something. So I just scrolled down my emails and I found a different Zoom link, the original one, and that's how
Okay,
I found you.
good. Yeah. So that's the one for all the regular classes. But I'm going to send real quick an email to everybody in case someone else has fallen into that same.
One on D2L works too.
It's on D2L. Okay, good.
Yeah.
Zoom link. My class.
Often Zoom will save the last meetings you've been on, and you can see it. It came up automatically for mine. It's William Fogel Zoom class. So sometimes it saves it.
Right. What happens to me sometimes on Zoom is if I have like totally logged out of Zoom, if I've exited Zoom, and then I'm coming back in, it always wants to like update it entirely, and then it takes a while to do that, and then it's hard to get. It sort of causes delay in getting back on. But anyway, here, let me send this to people. The Zoom link, let's see, hi class. Zoom class has started. There was some confusion about the right link. Here it is. As usual, I'll be posting the link to YouTube recording link after class. Okay. And also the discussion thread. Okay, I'm gonna make sure I got the right class. So every once in a while, I'll end up with having logged in on the wrong semester and send it to the wrong class. Actually, I haven't done that, but I can't come close. I've caught myself at the last minute from time to time. So Jenny, did you do the extra credit essays? Jason was pointing out to me that there's a certain amount of bait and switching that I did on those where I had different versions of the essays on the actual exam and in some of the notes relating to the first test. Did you do any of those essays?
I did do all three of them. I noticed little differences, but I kind of thought that, as the journalist that you are, that you just might want to see what we write. So I just wrote what I wrote.
Okay, that sounds good. Well, I have not graded those, and so your grades on the test will go up once I do that. Anybody have any comments about the test? I would go through it all and give all the answers, except that more than half the class hasn't taken it yet. They decided that they would have their spring vacation anyway. I was worried about them ruining their spring vacation, but now they're just ruining their second semester, second part of the second half of the semester. So to those folks who haven't taken the test and are watching the YouTube recording, I urge you to get that first test done, because we'll have in about 3 or 4 weeks, we'll have another test, and then the final after that. So, I mean, they're just going to be sort of piling up on you if you delay much longer. I always leave the test available till the end of class, because there are always some folks who don't actually get to it until finals week. Anyway, maybe that gives people a misimpression that they can just let it all go till the end. Hi, Ben. Let me give you some credit for being here.
Okay, thank you. Good. Did you have a good spring break?
I did have a good spring break. Yeah, I spent in Boise, Idaho, Napa Valley, California, and Tucson, Arizona.
Nice. Went to Memphis, Tennessee last weekend.
Oh, nice. What was that like?
Oh, it was awesome. Like I got to learn all about the Elvis mansion. I got to see a bunch of Elvis like archives at his museums, and even I got to have a tour of the Sun studio where him and Johnny Cash started their careers at. It was pretty cool. And I even tasted their barbecue. Barbecue is smoking good.
Yeah, it is good. Almost as good as St. Louis's. No, it's actually better.
I think it's better than St. Louis.
You think St. Louis is better?
No, Memphis is.
Memphis. I agree. I think Memphis is better also. Let's see. I want to give you credit. Let me get back to the grades. The only time I've been to Elvis's mansion was the weekend. This really dates me. The weekend that the time, it wasn't actually a weekend, that Ronald Reagan debated Walter Mondale during the 1984 presidential election. And the reporters covering that had lots of good barbecue, and we went and lit a candle outside of Elvis Presley's mansion. Although I have to tell you, I never really even liked Elvis Presley. Or his music, but that's just me. So now I've insulted Irish Americans. You weren't here for that, Ben. Yeah, I started out insulting Aiden, and now Elvis Presley lovers. So I'm doing great. Anybody else have anything interesting from their spring vacation? I woke. I was on a. So what I was doing is I was following my grandchildren around. I was watching my grandchildren. My youngest grandchild, my 5-year-old grandchild, who was traveling along with his mom and dad on a string quartet concert tour of the West. And so it snowed in Boise, which I had expected. And then the day we woke up in Napa, where I expected it to be beautiful, because this was a mountaintop Atlas Mountain Peak winery overlooking Napa Valley. I expected it to be beautiful, and it snowed the day we arrived there too. Fortunately, though, Tucson was nice and warm with all the cacti. But it was a fun trip. Anybody I was just, when Ben came in, I was asking folks if they had any questions about the first test, although I'm in general not providing answers, since most of the class hasn't taken it already. But if you have like something general, like that there were 2 versions of the essays. Okay, so let's move on then to New York Times versus Sullivan. And the second, third, or half of the course, the New York Times versus Sullivan. This is the director of the School of Journalism calling me, but I'm gonna call her back. The New York Times versus Sullivan is probably the most important First Amendment decision that the Supreme Court has ever handed down. The closest to it would have been Pentagon Papers case that we studied in the first third of the course. I mean, you know, Pentagon Papers saying the government, except under the most extraordinary conditions, cannot stop a speaker or the press from speaking, even if it can punish them for that speech after after the fact, in a defamation case or in some other, or even for potentially for publishing a secret in violation of the Espionage Act, like they're trying to punish Julian Assange. So that is maybe a close second, I think, to the New York Times versus Sullivan. New York Times versus Sullivan just applies in a lot more instances. Because it potentially, it doesn't just come into play during the printing of national security secrets, which while fairly frequent, is nothing like an everyday occurrence. But New York Times versus Sullivan applies in all instances where the media or a speaker is addressing a public figure, makes a claim about a public figure or a public official, that is contested by that public figure or public official. So it comes into play all the time. So when we're talking about New York Times versus Sullivan, the area of law we're talking about is defamation. What does defamation mean?
I'm just saying, insulting somebody's character.
Yeah.
Yeah, that's it.
And there are different kinds of defamation are libel and slander. Do you know the difference?
Slander is kind of more of just insulting what they like, their personality or their being instead of what they do.
Actually, the difference is slander is spoken and libel is written. They both can be about their personality, and in more and more cases of these defamation cases do involve, kinds of allegations that can get into intensely personal character traits or actions. I mean, I'm thinking in particular that there's a defamation case against President Trump, which where a farmer, is she a magazine publisher, says that Trump raped her in a New York department store. Trump said that was false. She's suing him for libel for saying it was false. I mean, he said it was false on I think on Twitter, because this was before he was kicked off Twitter, and that case is coming up for trial in the next few months. So I mean, that's it's an example of a libel case that involves intensely personal kind of claims. The other libel defamation cases that are getting a lot of publicity right now are the ones involving false 2020 election claims. There's one set of cases where Dominion voting machine company is suing Fox News and Fox News personalities who are virtually essentially journalists. I mean, I saw a headline today in the New York Times or Washington Post saying, "Is Tucker Carlson a journalist?" Or maybe it was one of the other Fox personalities, really a journalist. Well, you know, these personalities, they are journalists. And have the same kind of First Amendment protection that that any journalist would have. I mean, in some cases, they could even, as we'll see going forward here, when we talk about the case involving Larry Flint, a media personality who is conveying their message in a particularly colorful or hyperbolic way may have even more protection. So even though that might seem counterintuitive, but it's sort of it comes out of the Supreme Court's wanting to protect parody and humor and editorial cartooning and you know, that kind of colorful critical commentary about public officials. So there's the Dominion voting suits against Fox News and Fox News personalities. That case has not yet gone to trial, but there have been depositions. There's been pre-trial discovery where Rupert Murdoch, who owns the Fox and the Wall Street Journal and a bunch of other publications around the world, was deposed about and made some comments that were interesting. And so New York Times versus Sullivan applies directly to that case, and the standard laid down in New York Times versus Sullivan. So it's sort of, I mean, one sort of interesting side note about that is that the Supreme Court definitely had the civil rights movement in mind when they wrote New York Times versus Sullivan. And but it's in the Dominion voting systems versus Fox News, it's definitely the conservative medium of Fox News that is relying on the tough standard that was laid out in New York Times versus Sullivan. So it's protecting Fox News in this case, where it protected New York Times in New York Times versus Sullivan. I mean, it's important that constitutional rulings apply regardless of politics. I mean, sometimes that's a goal more sought than achieved, but it's really important to legitimate constitutional interpretation. By the way, the any kind of false defamatory statement on Twitter or social media, that's sometimes referred to as twibble, but it's basically libel, and is judged by New York Times versus Sullivan standards. Although remember, and we'll talk about this more as we go forward, that in the case of a tweet, it would be like let's say Trump tweeted something about this Jean, I think her name is Jean Carroll, who said that she was raped by him in a New York department store, I don't know, 20 years ago. In that case, Trump, as the third party poster, can be sued, but Twitter cannot be sued because they are immune under Section 230 of the Communications Decency Act as are any other social media when it comes to the content of third-party postings. Third party in this case being, in that case, being Donald Trump. So the Dominion voting case is one of the defamation suits that grows out of the false information surrounding the 2020 election. Another case is one where you all may, if you watched any of the January 6th hearings, you might have seen the testimony of two women from Georgia who became the victims of a lot of online hate and false allegations regarding vote counting in Georgia. I think Atlanta in particular, claims of having like dead people vote and having hidden ballots that they added into the total and that stuff, none of which was ever for which there was ever any kind of evidence. I mean, there were a couple of dead voters, but didn't have anything to do with these women, and it didn't have anything to do with the results of the election. I think the findings were there were maybe 6 or 9 dead voters in the final analysis, and that's the final that's a final analysis that Trump's hired organization came up with. These two women who testified before the January 6th commission, one is a black poll worker, and another, her daughter, who also was a poll worker, and who were the subject of all sorts of threats and insults on the internet and physical threats of violence. They have sued an online news organization. Well, not really a news organization, but an online organization called the Gateway Pundit. Have any of you guys ever heard of the Gateway Pundit? The Gateway Pundit is a blogger out of St. Louis, Missouri, and even though you haven't heard of him, he has a greater following on the web than the St. Louis Post-Dispatch or the Riverfront Times or any of the established St. Louis Public Radio, any of the established news organizations in St. Louis. I mean, he has a huge online footprint, and he published stories saying that the Dominion people were counting dead voters and making up ballots, and that Dominion voting machines were changing Trump votes to Biden votes, and that that Dominion was owned by communists with connections to the Castros and to Venezuela's former communist leader. All of these things were false, but although Trump is still claiming he won Georgia. So this is there's a defamation suit in the city of St. Louis on the basis from those two Georgia poll workers. And I believe there's another Dominion case that's in court in Colorado. So there's a number of defamation cases around the country. I mean, these are the damages that are sought are really large damages in the billions of dollars. So these are even much bigger claims than New York Times versus Sullivan was. So let me set the stage for sort of the setting for New York Times versus Sullivan. I mean, this is a time. Were any of you alive in 1964? That's what I figured. So in 1964, I was in 10th grade, and 1964 was the year that the Civil Rights Act finally passed over us over a filibuster by Southern senators in the U.S. Senate, and finally became law. So, if you like putting those civil rights big events in a chronological order, 1954 was Brown versus Board of Education, in which the Supreme Court said segregated schools violated the Equal Protection Clause of the 14th Amendment, and overturned a case called Plessy versus Ferguson that had said separate but equal schools were good enough for equal protection. So that was an 1896 case. The Supreme Court in 1954 overturned it in Brown versus Board of Education. That was the opening sort of shot of the Warren court. Warren being Earl Warren, the former governor of Republican governor of California, father of Jerry Brown. No, okay, forget that. Not the father of Jerry Brown. Pat Brown was another governor of California. Let me restate that. So Earl Warren was the governor of California before Pat Brown. Earl Warren was a Republican. He ran for president. He was appointed to the Supreme Court by Dwight Eisenhower in 1954. And so this was his first major case. And it overturned this 60-year-old, almost 60-year-old, 58-year-old precedent of separate but equal, and said that schools across the nation had to be desegregated. And that inaugurated this school integration all across the country. And it also was the first in a long line of very sort of liberal rights, civil rights and civil liberties expanding decisions by the Warren Court. Earl Warren was the Chief Justice until 1968. And during that period of time, that was by far the most liberal Supreme Court that ever sat. And, very much of a far cry from the Supreme Court we have today. And so this New York Times versus Sullivan was coming to the Supreme Court at its most liberal moment. Earl Warren was the Chief Justice. Arthur Goldberg, who later became a United Nations ambassador, was a very liberal lawyer from New York. Abe Fortas, another liberal New York lawyer. William Brennan was the most liberal justice on the Supreme Court and advocated what is referred to as a living constitution, that the Constitution's interpretation shouldn't be limited to what the founding fathers meant when they wrote the text into the Constitution, but what the words they wrote mean today. So, for example, the Constitution didn't have the word equality in it. And it was finally written into the Constitution in the 14th Amendment after the Civil War. But even when it was the people who wrote equal protection into the Constitution in the 14th Amendment, they specifically ran segregated schools in the District of Columbia. And they stated that they didn't mean that this gave equal rights to blacks to, say, serve on juries or to vote. Voting is another thing that's not protected by the original Constitution. So William Brennan in his Living Constitution said, well, the words they wrote were equal protection of the law. And equal protection of the law means equal protection of the law. And that means that you can't have segregation laws. During this sort of same period of time, or not really the same period of time, but the period of time that followed this was the time when Ruth Bader Ginsburg was extending those same words, equal protection, to include women who had been excluded from the original interpretation of equal protection in the 14th Amendment. The Supreme Court made very clear right after the 14th Amendment was ratified in 1868, that it didn't apply to giving women the right to vote or the right to be lawyers or really the right to do just about anything. And it really took Ruth Bader Ginsburg's entire career, both as a litigator, a civil rights litigator, and then as a justice, to come close to giving women equal rights under the Constitution. Although we still don't have an equal rights amendment that would explicitly do so. And of course, the Dobbs decision overturning Roe versus Wade means that women don't have the same control over their bodies that men do. So 1964, the Civil Rights Act finally passes over a filibuster. This is all sort of in the wake of all sorts of, this is the height of the civil rights protests in the South. I think 1963 was the year of the so-called freedom rides in the South, where Northern college students were going, mostly Northern college students were going to the South to participate in these marches against segregation in schools and colleges and transportation and marriage, etc. And so the freedom rides were like 1963. Martin Luther King's March on Washington occurred in right before New York Times versus Sullivan was argued before the Supreme Court. It occurred the summer of 1963. And then this case was argued during the 1963-64 term, and it was decided in 1964. During that period of time, from the time of the Civil Rights March to the decision in the New York Times versus Sullivan, John F. Kennedy was assassinated and Lyndon Johnson became president. Lyndon Johnson was from Texas, and sort of the sympathy. Kennedy had not been able to get the Civil Rights Act passed over the Southern filibuster because those Southerners were all Democrats. All of the Southern Democrats opposed passage of the Civil Rights Bill, and Lyndon Johnson, when he became president, a Southern Democrat who had been the majority leader of the Democrats in the Senate, was able to get the bill that Kennedy couldn't get passed through, and finally the Civil Rights Act was adopted. So this was, but the Supreme Court, when it met, was very concerned about what Southern courts were doing in libel cases to try to, that could have the effect of causing the Northern and national media to pull out of the South. The Southern segregationists, like Sullivan, the public safety director in this case, felt as though it was the coverage on national TV of the civil rights demonstrations where police dogs were being unleashed on young Black protesters in Birmingham, Alabama. High-powered fire hoses were unleashed on them. during the demonstrations in Birmingham, Alabama. This was also that Birmingham was also the site of the bombing of the 16th Street Baptist Church that killed, I think it was 4 young children in a Sunday school. Some of the Freedom Riders were killed when they went down in 1963 to the South in support of civil rights. When marchers marched on Montgomery, Alabama, for voting rights, I think one of the women from Chicago who had gone down there to drive protesters around was assassinated by a KKK person. 3 civil rights workers were found were buried in a dam in Philadelphia, Mississippi. A fact that was noted or in the news when Ronald Reagan, in launching his 1980 presidential campaign, launched it in Philadelphia, Mississippi. His campaign was very much targeted in winning over the South for the Republican Party, because in the wake of Johnson getting the Civil Rights Bill through in 1964, the Southern voters defected to the Republican Party and then became a prime voting bloc for first Richard Nixon and then Ronald Reagan. Ronald Reagan, he is very highly regarded sort of historically for a number of reasons, but I can tell you that civil rights is not one of them. He was pretty much anti-civil rights. So he did sign the Martin Luther King against the Martin Luther King holiday law that passed over his objection. He did sign. He didn't veto it. That was one pro-civil rights act that he took. So 1964, at the time of New York Times versus Sullivan, what the Supreme Court is concerned about is that all sorts of Southern courts and juries are issuing big defamation, libel judgments against Northern media, like the New York Times. There were dozens of similar large media judgments against the New York Times and against CBS and Washington Post and other national TV and media outlets. And the Supreme Court's concern was that these judgments would cause those media to pull out of the South. And in fact, the New York Times, the business side of the New York Times, advocated doing just that because of New York Times versus Sullivan's $500,000 judgment, which is paltry in today's terms. But New York Times was not the sort of robust company that it is today. It had just gone through a big labor strike, and it was having trouble meeting its payroll. And these judgments piling up in the South were a threat to their economic well-being. But the editorial staff went over in that proposal to pull reporters out of the South. But that's what the Supreme Court worried about. Did any one of you would any one of you like to present the New York Times versus Sullivan case? Jenny, does that smile mean yes, or is the red light on your microphone mean no?
I did write it out.
Okay, well, then you're stuck. just give us what you got, and then I'll fill in. Maybe some other folks can fill in some of it, or I'll fill in some of it.
Okay, I did write out a brief. The issue were statements in the newspaper. People were seeking libel judgments for what they believe to be protected speech. Facts, criticism of public officials, is it protected speech? Advertisements published in the newspapers, were they made with actual malice and they had to prove actual malice? The voting was unanimous in favor of the New York Times. The ruling was they held up freedom of speech, including politicians and public figures, to sustain a claim of defamation or libel under the First Amendment requires you to show actual malice, and the newspapers have a right to publish. The opinion, I don't know who delivered the opinion. Brennan.
It was Brennan. You're right.
Brennan. Okay. Just briefly in my notes, I just wrote that they had to show actual malice. Criticism of official conduct does not lose its constitutional protection merely because it is effective criticism and hence diminishes their official reputations. Whether or not a newspaper can survive a succession of such judgments, the pall of fear and timidity imposed upon those who would give voice to public criticism is an atmosphere in which the First Amendment cannot survive. Burden of proof does not mean false speech will be deterred. The New York Times and individuals have an absolute unconditional constitutional right to publish in the Times advertisements their criticism of Montgomery agencies. In my opinion, the federal Constitution has dealt with this deadly danger to the press in the only way possible without leaving the press open to destruction.
Okay, that's good. Yeah. I mean, you really have the high points. The actual malice standard. That's something that you need to take away from this. That when a public official or a public figure is the subject of a media report, that in order for that figure or official to win a defamation libel claim, they have to prove actual malice, knowledge, or which means reckless disregard for the truth, knowledge of falsity. This is one of the reasons that some of the depositions of Rupert Murdoch and some of the Fox emails from various Fox personalities to each other, indicating that they knew the 2020 election claims were false, but were broadcasting them anyway. That's one of the reasons that that's sort of relevant to the defamation case filed by Dominion Voting against Fox News. Do you remember what was Sullivan? What was the content in the New York Times that Sullivan was angry about?
I believe it was that there was violence going on that was not going on, or maybe I'm wrong.
You're not far. You're not far off. I mean, that is part of it. Hold on a second here. I want to get back to the grade, but that's part of it. In that, so there was an ad in the New York Times called "Heed Their Rising Voices," and
it's a long title.
Yeah, it was a long ad. It was a full page. It was a full page ad, and it was an ad that was put together by civil rights leaders. By the way, if you go to the announcements page where I'm talking about the second part of the course, and there's an attachment called NYT Sage, or maybe it's Sage NYT. It's a whole piece that I wrote on New York Times versus Sullivan. And so that will give you some of the background. So Heed Their Rising Voice is from a full page ad in the New York Times. And so it's not a story. It was not an editorial. It was an ad that the New York Times news site had not fact checked, nor had the advertising side. And so the ad was placed by Southern ministers who were leading the civil rights movement. Also, some noted Black entertainers, Harry Belafonte, Sidney Poitier, Marlon Brando, celebrities like Jackie Robinson and Eleanor Roosevelt, who was still alive at that point. The ad contained several mistakes. Most of them were minor, or at least one could have justified a liable judgment, even under the actual malice standard. The minor mistakes were that Dr. King had been arrested for, I mean, they said the ad said 7 times and he only had been arrested 4 times. The ad said they were singing My Country 'Tis of Thee when they were actually singing the national anthem. Then here this Jenny gets to sort of what you were alluding to. Students were expelled by the State Board of Education for not leading. Find that call too. The students were expelled by the State Board of Education, but not for leading. That was true, but the ad had said for a demonstration at the Capitol, but it was rather for demanding service at a lunch counter in the Montgomery County Courthouse on a different day from what the ad said. Most of the student body, not the entire student body, protested the expulsion. They boycotted classes. They did not refuse to re-register, as the ad said. The biggest mistake is the claim that armed police had ringed the student protesters at Alabama State and padlocked their dorm to starve them into submission. The dorm had not been surrounded, nor were officials trying to starve the students. That's the thing that came the closest to being able to actually meet the actual malice standard. The advertising department made no effort to check, instead relied on the good name of the civil rights leader who vouched for the signatures on the ad. His name was A. Philip Randolph, but the errors, there still were quite a number of errors, but all of them were errors of carelessness, reckless disregard for the truth, maybe on the padlocking the dorm, the dormitory dining hall. But the Supreme Court also said something else that was important in the case, and that was that Sullivan couldn't collect anyway because he hadn't been named in the ad. His position, the actions of his department were talked about, but there had been no mention of Sullivan. Now, if one were to be, there is a legal criticism of New York Times versus Sullivan that can be leveled, and that is that if the New York Times, if the Supreme Court thought that Sullivan couldn't collect because his name wasn't mentioned, they could have issued an opinion on that basis alone and not gone any farther. There is a philosophy of judicial restraint that the Supreme Court sometimes adheres to and sometimes doesn't. And they certainly didn't in this case. Judicial restraint means that the Supreme Court should only answer the questions it has to answer to decide the case. So the only answer it had to get to was, does a person who's not named able to collect a liable judgment? Answer is no. And they wouldn't have gotten to actual malice or the need for breathing room in a democracy for mistakes in news reports or public claims about public officials. They wouldn't have gotten any of that stuff. By the way, Martin Luther King was in the audience at the time of New York Times versus Sullivan oral argument, and one of the justices, I think it was Justice Goldberg, sent down a copy. No, I think it was Justice Fortas, maybe sent down a copy of what was then a recently released book by Martin Luther King to get an autographed copy. So it was pretty clear who the Supreme Court was paying attention to. But I think I don't really, even though I think judicial restraint is a good principle for the Supreme Court to follow, that I can certainly see why they didn't in this case, given the civil rights background of what was going on in the country. They wanted to put an end to this rash of lawsuits in the South that were jeopardizing the coverage of the civil rights movement, the coverage that was so important to bringing about an end to legal discrimination and in the South and in the rest of the country as well. This was really a judicial revolution. One of I asked you all to, one of the books for you to buy is the book by Anthony Lewis, he was the Supreme Court reporter for the New York Times at the time of New York Times versus Sullivan, and he stressed what a revolution this was. Up to this point, states were entirely in charge of libel and slander and defamation. These were state laws we're talking about, and what the Supreme Court did was it nationalized defamation and applied this first overlying First Amendment gloss to any defamation case in any state anywhere in the country, based on the First Amendment, and that was revolutionary and had an enormous impact. Even though, as Jenny said, the Supreme Court was unanimous in its decision, it wasn't a very popular decision within the court, partly because some of the things that began happening around this time. I mean, Justice Brennan himself was sort of angry at the press, and it became there were lots of negative stories about William O. Douglas, who was if you'll remember back, it was sometimes Brennan's joined Brennan in dissents and on the liberal side of some of the First Amendment cases. Brennan was the former New Deal senator who was a womanizer. He had married a young woman law clerk. The Republicans, Gerald Ford, when he was the Speaker of the House, wanted to impeach him. He got and Brennan wasn't very happy with the press for that reason. Then, after Warren left the court in 1968, Lyndon Johnson appointed Abe Fortas to take Lyndon Johnson's place. Then the press disclosed that Abe Fortas had gotten paid by a lawyer connected with a case that came before the Supreme Court. And so Fortas had to withdraw from the nomination for Chief Justice had to be withdrawn. And I think Fortas was actually forced off the case. This gave the incoming President Richard Nixon a chance to make a number of appointments of rather conservative justices to the court. A new Chief Justice, Warren Burger, a fellow Minnesota judge, Harry Blackman, William Rehnquist, who is the very conservative lawyer from Arizona, Lewis Powell, a sort of gentleman's lawyer from Richmond, Virginia. So a number of Republican lawyers and judges were added to the court, and it moved back to a more conservative position than it had been in during the end of the Warren Court. But I mean, keep in mind that even though there was that movement, that there were still quite a number of very liberal, even with those four justices who Nixon was able to add to the court, even with them joining the court, there were a number of very important progressive decisions that have come since then. Roe versus Wade was 1973. That was after the end of the Warren Court. And then, when you get a lot of the decisions on equal protection, protecting women's rights in terms of schools can't fire women teachers who become pregnant. The defense of the decision throwing out state laws that made interracial marriages illegal. And eventually all of this leading to the decisions that said state laws that made same-sex sexual relations in your own home illegal, and that made same-sex marriage illegal, all were unconstitutional. And that in fact same-sex marriage was part of a constitutionally protected right. So all of that progressive development in the law occurred after first Nixon and then later Reagan were able to add some very conservative justices to the court. And partly that was because not all these justices turned out to be as conservative as they might have originally been thought to be. Burger and Blackman voted in the majority on Roe versus Wade. As a matter of fact, Blackman wrote the opinion. Later, when Reagan appointed Justice Kennedy to the court, Kennedy turned out to be the deciding vote in all of the same-sex cases, all of the gay rights cases, that states couldn't pass laws making same-sex relations illegal in the home, that they couldn't pass laws, that municipalities couldn't discriminate against same-sex couples moving into a neighborhood, and that same-sex marriage was protected. Justice Kennedy was the deciding fifth vote in all of those cases. So it turned out that the justices appointed by the Republican presidents didn't always end up voting on the conservative side of the issue. Justice Powell, who I mentioned earlier, was the middle vote, prolonging constitutional protection of affirmative action. And Kennedy and Justice O'Connor, a Reagan appointee, also found themselves in the middle of the court. Justice O'Connor protected affirmative action, abortion rights, and so a number of those Republican appointees turned out to be middle of the rotors, who ended up actually being decisive votes on the court and controlling the direction of the court. What's changed in the last, with the three Trump appointees, in the last couple of years is that there are at least 4 conservative votes that are almost always cast on the conservative side of things. Thomas, Gorsuch, Alito, and Kavanaugh. And leaves the Chief Justice, who is a conservative, sort of in the middle of the court, sometimes allied with the 4 Democratic appointed justices, all of whom are now women. And sort of what's the middle, the sort of question that remains on the current court is whether sometimes Chief Justice Roberts will be able to lure Kavanaugh over to his side for a middle of the court that sometimes will agree with the 3 Democratic appointees. Roberts tried to do that in the abortion case, the Dobbs case, and failed. Kavanaugh wouldn't come. But there have been some other cases where he has been willing to. On the reliably conservative end of the court, I left out Amy Coney Barrett, who is reliably conservative. So it's the current court is the most conservative court since the New Deal, 1936, when Roosevelt tried to pack the court because it was throwing out all of his New Deal legislation. But then a justice switched sides, and the switch in time that saved 9, and the Roosevelt court packing was voted down. There are a couple of bills in the Congress today the Democrats have filed that would pack the court. I saw a reference to one that was filed recently that would force, have a required retirement age that would force Thomas off the court. I think those are unconstitutional because the Constitution says that a justice's tenure is for good behavior. In other words, life. They can be impeached, but they can't be forced out on mandatory retirement, at least in my opinion. But like I say, even though the court was unanimous 9-0, it was not. Not all the justices were happy with it. Brennan didn't like what they were. The author of the opinion and biggest supporter didn't like what they said about Douglas and about Fortas, and Justice White never really. He was the Kennedy appointee who had been a pro football player, Heisman Trophy winner. He never particularly liked New York Times versus Sullivan, and so there was some thought that the Supreme Court might end up reversing it. Even though it had 9 votes in the beginning, once all these 4 Nixon appointees joined the court, it was thought, well, maybe it will be overturned. And it was the Larry Flint case that pretty much showed that that New York Times versus Sullivan was going to endure. Who wants to present that case? Falwell versus Larry Flint. Do those names mean anything to you guys?
Well, I hadn't actually seen the movie, but I knew of the movie, and I've heard of the case because of Hustler and everything. But I was actually reading about it earlier.
You want to tell us a little about it?
I didn't really read much about it, except for I liked the preview of the movie, which made me more interested in to see that. I
Yeah.
barely got through a few paragraphs this morning, then I had stopped, so I didn't
Okay.
really read much.
Well, I'll
Apologies.
take it over. I think Justice Blackmun played the judge. in the, you know, the acting part of the movie. I've never actually watched the movie. So Jerry Falwell was he was the most famous religious fundamentalist in the country. I mean, Billy Graham was still alive at this time, and so he would have been the most famous sort of Christian evangelistic minister. But Jerry Falwell was a much more sort of like politically oriented minister, and he was very much allied with the Reagan administration, and so sort of the rise of Jerry Falwell was around this time of you know, the Reagan Revolution and all. And Larry Flint, as you mentioned, Jason, was a pornographer who published this Hustler magazine, and I have a link in the syllabus to the ad. You know, the ad says basically that Jerry Falwell had sex for the first time with his mother in an outhouse, and very small type at the bottom. It says this is a parody, and so the case was, you know, Jerry Falwell claimed this wasn't really a libel case. He claimed it was inflicted emotional distress on him, and he had a very sympathetic jury in Virginia, his home state, $500,000 judgment, about the same size as the New York Times judgment. It was appealed to the Supreme Court, and the sort of stunning thing that happened in this case was that William Rehnquist, you know, this paragon of conservative virtue, wrote the opinion on Larry Flint's side, on the First Amendment side, and even more shocking was that he relied upon New York Times versus Sullivan, which he had oftentimes criticized, and so this was the fact that he relied on New York Times versus Sullivan was evidence that New York Times versus Sullivan wasn't going to get overturned, despite the grumbling within the court about it, and that it would persist. I mean, there's still Justice Thomas wants to overturn New York Times versus Sullivan. I think Gorsuch has said some things like that too, but I think it's pretty safe. Say at any rate, back to Falwell versus Flint, or I guess this is Flint versus Falwell. So there's no question but that what's depicted in the ad is false, and that he knew it was false. But the Supreme Court said that there's this special protection for parody, and so it was going to apply the very high, tough test of New York Times versus Sullivan because parody was involved. Of course, if you actually applied the test, knowledge of falsity, I mean, in parody you have knowledge of falsity because you're making this stuff up, but so it doesn't really fit very well. But it was the most press protective constitutional standard, and so so this was the sort of strongest statement that Rehnquist could make in favor of the strong First Amendment protection I sat next to, I was at a conference where I was sitting next to a woman who had written a woman who had written a friend of the court brief on behalf of cartoonists, political cartoonists. And they knew Rehnquist well enough. This particular lawyer knew Rehnquist well enough that they knew that Rehnquist was somebody who was really interested in political cartooning and dabbled in political cartooning himself when he was a student at Stanford University. By the way, there is a question on one of the tests about whom did Justice Rehnquist date during his time at Stanford University, and the answer to that question is Justice O'Connor. Although she wasn't a justice yet, they were top students at Stanford University Law School, and they went out on a date together. Justice O'Connor was the first woman appointed to the Supreme Court appointed by Ronald Reagan. Of course, when she graduated from Stanford and tried to get a job, they still weren't giving jobs to women lawyers, and she had to start out as a secretary. But she managed to make it up to the Supreme Court. At any rate, so this woman lawyer was telling me about writing this brief in Hustler v. Falwell about that was on behalf of the nation's leading political newspaper, political cartoonists. And so what they did was they included the whole, all sorts of cartoons from history. Herb Bloch's cartoons showing, from the Washington Post cartoonist showing Richard Nixon with always having a 5 o'clock shadow. Boss Tweed cartoons from the 1800s, referring to the Tammany Hall control of New York politics by the Democrats, cartoons that Rehnquist loved. And so, Rehnquist in his opinion says that, even though, so they knew that he was susceptible to this appeal, and it shows up in his opinion that this was persuasive, because he said that even though the parody in Hustler was a poor cousin of these great political cartoons, that there had to be special First Amendment protection for parody, and that it was broad enough to protect Hustler's parody of Jerry Falwell. And that New York Times versus Sullivan was the precedent to rely upon, even though it didn't really make sense. So that lawyer who wrote the friend of the court brief told me that one of the cartoons that they had looked at for possible inclusion in the brief showed Rehnquist in a Ku Klux Klan robe denying blacks the vote in Arizona, or Hispanics. I don't remember if it was, I think it was blacks. And which both times, both in his original confirmation hearing and later his confirmation hearing for the Chief Justice, one of the main arguments against Rehnquist was that as a young Arizona Republican lawyer, he had tried to block voting for blacks in Arizona at the voting booth on voting day. And so this cartoon depicted him doing that in Ku Klux Klan robe. Well, they didn't put that one in the list of cartoons that really needed to be protected. But she told him once about how they kept that out, and Rehnquist, who had a really good sense of humor, thought it was very funny. Rehnquist was sort of a dry, droll sense of humor. And I mean, his one thing I really like about his opinions, even though I disagree with most of them, is that there's nothing extra. He doesn't go on with all sorts of, he doesn't he doesn't say anything he doesn't need to say. It's just the very basics. So I sort of like that just from a legal and composition point of view. Okay, so that's Hustler v. Falwell, which sort of breathed new life into New York Times versus Sullivan. One other case that I had on the syllabus is the Milkovich case. Did anybody read that? So the question here is opinion. To what extent is opinion subject to a libel suit? And at the time of the Milkovich case, which I don't know, it was in the late, I think it was in the mid 90s. This was written by Rehnquist too. At the time of the Milkovich case, the Supreme Court had said in a number of cases, they had said, opinion can't really be the subject of a libel suit. But they had said it in what people refer to as dicta. Dicta means it's language in an opinion, but it's not the holding of the opinion. It's not the law, not the statement of law. So it was just something that the justices in writing opinions about defamation had mentioned in passing, but that wasn't part of the ruling of any case. And Rehnquist said, in fact, some statements of opinion can be the subject of defamation. Those statements of opinion that are based upon reliance upon specific facts, if the opinion is misstating the facts, can then be the subject of a defamation award. This case involved a sort of storied wrestling coach for a Maple High School in Ohio, who, and it involved his teams won the state wrestling title year after year, and they had a controversial meet. Well, I think racial. I think it might have been against the black team, and there was basically a riot, and then the educational sports authorities in Ohio had a hearing at which Milkovich, the coach, testified, and a sports reporter wrote a column for the sports page saying that anyone who was at the wrestling meet and heard Milkovich describe his role during this sports hearing would know that he wasn't telling the truth. And Rehnquist said, this is the kind of statement that's based upon a particular set of facts. And so if the facts were wrong, that Milkovich, that opinion was based on basically accusing the wrestling coach of perjury, that if the facts were wrong, then there could be a defamation case. And the first reaction of the press to this was the sky is falling, because it was thought that there could be all sorts of opinion that was subject to defamation awards. But in fact, that hasn't happened. And in fact, a lot of Supreme Court, a lot of lower court decisions in defamation cases involving give opinion almost the same kind of protection as parody. And so they don't hold the journalist to as high a standard as in a straight news story. And I mean, I think to a certain extent that's appropriate. And it softens the impact of what people thought the Milkovich decision by Rehnquist had resulted in. A number of Donald Trump's statements where he has been sued for defamation. He has been able to get off on the basis that he was just stating an opinion or just exaggerating for effect, that it was just parody, or it was just kidding. You know, I think he maintains, for example, this didn't relate to a libel case, but he maintains that when he said, hey, Kremlin, if you can get us Hillary Clinton's emails, that'd be great. That it was just a joke. And so therefore he shouldn't suffer any kind of consequences for it. So that pretty much covers the area we're going to cover today. Any questions? Let's see. One is next week. We're going to have a special class, and it will meet an hour earlier. I mean, you'll still be able to, if you can't get there till 10:30, you can skip by. Okay, it'll meet 9:30 to 11, and we're meeting together with a photojournalism class down in Carbondale, and we have a visitor who the School of Journalism is being provided by the Pulitzer Center on Crisis Reporting. And this is a woman who was this is a woman who was a political prisoner in Iran and was held in solitary confinement for a period of time. Then she became an activist in the United States in opposing solitary confinement, which is pretty used, much more widely than many of us realize, in prisons around the country, including the federal prison at Marion. And so this woman became an activist opposing solitary confinement. She then composed a play called The Box, where the actors, it's a small cast play of about 6 or 7 people. She plays one of the parts, and it's just prisoners on a solitary confinement cell corridor at San Quentin, who and guards and their families, or some of their families. It's called The Box. And they did a national tour with it last summer. I saw it in St. Louis. So she's going to come talk to us about solitary confinement and about her the artistic expression that she engaged in to try to draw attention to it. So that will be our class next week. I'll write you an email that has more details about it and some readings. That'll be our class next week, 9:30 to 11, I believe. And then we'll be back to the normal time the week after, and read all the cases involving schoolhouse. It's the next lesson, schoolhouse searches. Mary Beth Tinker and her Black Armbands, Protest the Vietnam War, Hazelwood versus Kuhlmeyer, St. Louis high school paper that wrote stories about issues facing women, from birth control to divorce to being unwed mothers, and on to the most recent case where a young student who was upset about not getting on the varsity's cheerleading squad put something on social media using the F word in relation to the coach, and the Supreme Court protected her speech. So we'll talk about those 2 weeks from today. Any questions?
So that meeting next Wednesday, did you say it's gonna be in person at the comms building?
Well, you can do either way. I'm not going to be there. At least I don't think I'm going to be there. I mean, I think I'll be online. I mean, I might be there because I am helping sort of host this person. So yeah, I'll give you the room number. The room number is the one that Julia Rendelman, our photojournalism professor, teaches in. So it'll be in Julia's room, and it'll have a Zoom hookup, so you can do it either in person or online. And I haven't figured out yet which I'll do.
Okay.
Maybe I will come down there.
Okay, thank you.
Okay, great. And I'll put that in the email that has more details. Okay. See you all later. Bye-bye.
Oh,
See
okay.
ya.
Bye.